So thanks for joining. My name is Jaron Dean. I'm the president of NALTO. We are very, very excited about this session that we have. As you know, the world that we live in is extremely dynamic and complex. The world that we're staffing in. As a result of COVID, nurse staffing had a surge that we're all aware of. That surge led to pressures on hospital systems, healthcare systems, right? That in turn, I think, maybe that's not the only reason, they might have a different opinion, but it certainly put pressure on these systems to the point that legislation at the state level came in, right, from a nursing perspective. So NALTO was introduced to Ackerman. I know we've got some phonetic problems. It's Ackerman, it's not Ackerman. They said as long as we're saying their name, they're happy. So even if you say Ackerman, they won't get too mad. So we met Ackerman through Amber Spring at Healthcare. So some of you know Amber. She's does the government relations and affairs for Caliber, I think is the name, right? And she introduced us to Sarah and Monte, who I've got sitting with me at Ackerman. They were working with the ASA. You guys work with the ASA, right? You did as well. They understand the nurse staffing issues really well. We felt like it would be nice to leverage their knowledge from the nursing perspective of all these laws, because that's where they were sort of born from and primarily directed to. And leverage their knowledge, and they put together, we'll talk about what's in front of you, this little giveaway, which is also on the NALTO website. We leverage their knowledge, engage them, so we have an engagement with them to help us with these state issues, understanding them, strategy about how we would approach them, to get clarification, perhaps lobby, perhaps contest in some cases. So I'm very excited to be with them, and I want to thank them for being here. So if we go to the next slide. To my far right, I have Sarah Rosenbaum. She's a partner in California, LA office. And like I said, Sarah's been working on these nurse staffing issues for a very long time. I'll let her talk a little bit more about herself and her background. And then to my immediate right, I have Monte Sigmund, who is also a partner with Ackerman, but in Florida. So you got two ends of the coast here represented. And so I'm just excited to have them here. I'll turn the time over to, who wants to go first?
I'm the top one.
All right, let's go.
Thank you so much, Jaron. Hi, everybody. Thank you so much for having us here. I just want to quick ask, can everyone see us?
And we're kind of low.
Is it weird? Do we need to pop up and walk around a little bit? Yes, we need to pop up and walk around a little bit. I'm a litigator, so I don't sit down in court, okay? That's not cool. So I just want to quickly give context a little bit. Jeremy, thank you for that introduction. I have the true pleasure and honor of running Ackerman Staffing Law Sector team. We do all this stuff. Here are some of the people. That's Monte, that's me. And what we do for our clients is try to bring holistic and synergistic legal advice across different areas so that it makes sense for you and for our clients. As Jaron said, I have a lot of experience. I've been working for something like 12 years. I've been defending class actions and complex litigations for staffing companies and have learned the industry over the years and have learned so much that this industry, and I know locums is different than nurse staffing, but it's often square peg round hole legal issues. And I mean, nothing is more like that than some of the stuff we're going to talk about today. And so over the last 10 years, we talk a lot about how do we get there? How can we remain flexible, resilient, develop approaches towards compliance, and make risk decisions that benefit our companies and allow us to do business in those states. So that's what our practice is about, and happy to answer any questions more generally later on. Okay, I also, just because I'm a lawyer and because I actually formally represent NALTO, I just wanted to give you some quick antitrust admonitions. You guys are competitors, right? NALTO is a trade organization, okay? What we want to do is make sure that we are avoiding antitrust scrutiny, that we are not making collusive decisions, we are not breaking up territories to say, hey, I've got New England, you've got the Southwest, whatever. We're not sitting around and agreeing on prices. We are here to get better so that we can compete more fiercely. Okay? Keep going. Here's what you shouldn't be doing, okay? If anyone's feeling weird about an antitrust issue, walk away from where you are, okay? It's not worth the conversation. Okay. Framework for discussion. We're gonna talk a lot about the state regulations today and approach for how to do it. I just wanna set up in everybody's mind, we're gonna talk about what is now, okay? There's a strong interest, we know, in changing the law, okay? That is an important conversation. It's an ongoing conversation, and our primary focus now is what do we know about what the law is, okay? So I just want to make that clear that there are opportunities for discussion of change and efforts for change. Jared alluded to them earlier, but we want to mostly talk about what is, okay? Also, Monte is way better at this than I am. I mean, in fact, Monte is the one I call about every single one of his questions, but we're not encyclopedias, okay? This is complicated. Jared's gonna talk a little bit about how we've tried to make this stuff easier for you guys to navigate, but like, just no one please ask me a quiz about like, well, in this state, on this provision, in this thing, we can talk later, we're gonna need to look at our, we need to look at our books to answer those questions, okay? Anyway, I think in general, we're ready to go. Okay.
All right, so we wanted to sort of clarify and make sure we're all on the same page to start with about the law. And one of the things is, what is a local tenants agency or organization? Historically, right, it was doctors. It was agencies that placed MDs and DS positions. But over time, that has expanded, right, to include other types of advanced practitioners. Here today, we are going to be focused on physicians, so the traditional sort of working in business. We're going to talk a little bit about physician assistants and whether these laws apply to them. And we're going to talk about advanced practice registered nurses, including people like nurse practitioners. I use APRNs to sort of include, clinical nurse specialists, CRNAs, all that bucket of advanced practitioner nurse types. What we're not going to cover today because of the complexity of this area and just the amount of time that we have is the application of these laws to other types of practitioners, such as physical therapists or occupational therapists, psychologists. There's a little bit about that in the Mountain Guide, but we're not going to be able to touch on that subject today. So one of the questions that we have, just to sort of orient us on who you are, is how many of you are only placing physicians? Only. Raise your hand. Okay. So I'm not seeing any hands raised. So everyone here is placing some other type of practitioner in your locum tenens, some very, very, very business lines, but in your locum tenens business division or business line, you are including some other type of advanced practitioner. Is that right? Okay. Oh,
You hear this one?
That's the only one that's working.
It's not anymore.
testing? Nope.
All right, we'll just yell loud.
Okay. I'll do my best.
You don't have batteries?
How many of you are placing physician assistants? Okay, so that's a good number of hands. And how many of you are placing advanced practice nurses as part of your locum system? Okay, so that's a good number of hands. And what about something else? Is anybody making placements of something else? Okay, a few hands. Okay, that is helpful for us to sort of think about, the amount of time we spend on the concept of health care. any more hands? So we want to talk just briefly, right, about what are these laws and what are the terms that we're using. When we say state laws, we are talking about state laws that are called by a lot of different names, right? Nurse agency law, temporary supplemental staffing agency. There are tons of names, but fundamentally, we are talking about laws that regulate temporary placements of some sort of, medical personnel, right? Many of these laws, as Darren alluded to earlier, are really directed primarily at nurses, but because of ambiguities in the law, they could potentially be read to apply to other types of practitioners, including even physicians. And we'll talk a little bit about that in a minute. When we talk about the law, we are sort of referring to the collection of things here. The statutes. A statute is what the state legislature actually enacts. It's a bill, it gets codified into state statutes. That's sort of like the highest level of law. Then the Department of Health, the Department of Labor, depending on where you are, looks at the law and puts out regulations to interpret and further apply the statute, right? Some places, the regulations in our modest have gone really far beyond what the statute actually says. But so the regulations, though, once they are in final form and have been issued and published and have gone through the proper rulemaking process, those have the effect of the statutes. They have to be followed, and a failure to comply with the regulations could get you in trouble. Guidance is less formal. It is typically something issued like in the form of FAQs. It has not gone through the formal rulemaking process, and so it is helpful, but it is not the same as a regulation that has gone through proper rulemaking. Okay, what are we talking about when we talk about these laws? I mean, it depends on the state, but we see a couple of things sort of permeate through most of these laws. One is the requirement to register or obtain a license. And that, depending on the state, is a very easy process or a somewhat more complex process. The other thing that we see is some sort of required reporting, some sort of submission of data to whoever the state regulator is. It might be invoice data, billing data, depending on the state. It can be quite intrusive. Is it better? Is that better? I think so. Okay. So depending on the state, the reporting can be very onerous and it can be very frequent. Some states require quarterly reporting. Some states require it twice a year. Some states require it once a year. It just depends on where you are. And then we see a mixed bag of other stuff. Prohibitions on conversion fees, rate caps in some places, like Massachusetts, for example. Oregon is about to start their rate setting process. Certain insurance requirements that you, for example, maintain workers' comp on workers who are subject to the state healthcare staffing law. It really depends. And what that means is there is not a one-size-fits-all approach, which makes it extremely difficult for all of you to actually know what's required and comply with all of these laws. All right.
We're having fun with our audio.
This one work? They're trying to figure it out. Oh, yeah. So when I first had this Zoom call with Monte and Sarah, it was a Zoom call and you pulled up this spreadsheet. She had this spreadsheet and I was like, I gotta have this spreadsheet because she was at all these tabs. And as a CPA, I was like, she did it on a spreadsheet of all things. And I was like, it had all these states and all this information. And I was like, how do I get this? And that's where this was born. I said, make it a little prettier for us, right, than a spreadsheet. And so this is a summary, and as you can tell, it's 92 pages long. So, I mean, how many states do we have in this total?
25 total.
25 total states. So we engaged Ingerman to prepare this. This is on our website. Now we printed a copy for you today so you can thumb through it and get familiar with it as we're talking about the issues. But it is on our website behind the login, and the PDF is infinitely more powerful because it has links, and if you click on those links, it'll take you to the actual statutes and regulations, things like that. In addition, we have engaged Ackerman to update this quarterly. So they gave it to us in December. You haven't seen it. That's when we first got it. Just last Friday, they gave us the first quarterly update. And in true attorney fashion, the updates are going to be red line, right on? Okay, so, and then we suggested, right, that maybe second quarter would be blue line, and then, you know, the third
A
quarter.
rainbow of colors.
A rainbow of colors, so that you kind of know and keep track of what has changed with each distribution of this guide. In my opinion, I mean, we did a contracts and insurances best practices document on the legislative committee. I thought that was a huge resource for NALTA. I thought it was probably the best resource we had to date. I think this trumps, I think this is the best resource that we have as NALTA members, because when you start to dig into the stuff, it can be overwhelming. And what you're gonna find today, as we go through, they have some pretty cool maps. And when I saw the maps, I just fell in love. I was like, this map, I gotta get my hand on this PowerPoint. So they sent it to me, and it's now saved on the desktop. So you're gonna like these maps that they've got, and we'll make that available as well after the conference, but you're gonna be first to see it. So very, very excited about this. So does that give a good framework for this?
Yeah, so I was gonna say, one thing that we've added for this most recent edition, this March edition of the guide, is we put this chart at the very front in the what's new section, is also new. And it right now it just includes physicians, PAs, and advanced practice nurses, but it just gives you a handy quick reference, yes, no, maybe, probably, about whether that particular state law is likely to apply to that type of practitioner. Now, here's the caveat. Some of these laws apply to physicians, but only if the physician placement is in a certain type of facility. For example, long-term care. You have to actually, I'm sorry, go and look at the law, and the guy will tell you sort of what facilities are encompassed. But you have to look and see, okay, am I placing a physician? Is it in this state? And at what kind of facility, to figure out, am I potentially, making myself subject to this law? So I wish it was.
I think Missouri is a good example of that, right? Missouri is one where the definition has physician, but then it goes to the setting.
Yes, New York is a terrible example because, they apparently decided, the Department of Health in New York has decided it applies to physicians and healthcare facilities without really any sort of limitation. That is not the case in most states. Most states do have it circumscribed to hospitals, long-term care, residential facilities. So just keep that in mind. This is not a stopping point unless it has the word no. You can stop there if it's a no. And if it's in a state and a practitioner says no, that's fine. If it's a yes or maybe or probably, I would encourage you to continue your analysis. This already.
Can I just add one more point, just because I'm the one with the admonition today? This is general, right? This was prepared by us for now. So there is a giant disclaimer on the bottom here, right? Get your own legal advice. Like if you're about to do a big deal in a new state, take the time to have your counsel go and review and double check and make sure in the context of understanding your business and understanding the relationship, et cetera, that you're doing the right thing. But I mean, we feel confident about this completely, but again, we don't know the specifics of your business.
And there's a lot of perhapses in there,
Yep.
or maybes, but that's where your own analysis has to come into play, and your own business decisions, certainly. So.
Okay, so what state laws apply? Like I was saying, this is a little bit more complicated than is ideal, frankly. And it depends on the type of practitioner and the type of facility. Other factors may be relevant depending on the state. So today, we've sort of broken this down by practitioner type. We're gonna start with physicians.
Isn't that a great map?
Yay! So this map shows you the states in red are the places where there is a law. Just if you read the law on its face, it looks like it applies to physicians. The application can make it on the type of facility, but if you are making placements in any of these states in red of physicians, I encourage you, please take the time to do the analysis. We're potentially subject to one of these state laws. Let me talk a little bit about New York. So New York, the rollout of that law has been frankly a mess. And the law applies to healthcare personnel, which, and if you read the definition of healthcare personnel, it's fairly circumscribed. It applies to nurses, licensed practical nurses, and certain other licensed or unlicensed staff. The Department of Health has taken a very broad interpretation of other staff in that definition of healthcare personnel. And based on their position so far, New York has decided that its law applies to physicians and other types of healthcare personnel, including, PAs, advanced practice nurses. And there's no limitation on the healthcare facility type. So any placement temporary in New York of a physician, congratulations, you are subject to that New York law as it's being interpreted and applied by the Department of Health.
On that point, Monte, at our board meeting yesterday, Sean went to the FAQs, right? Because we were curious about, well, because it saved physicians on the FAQ website, and it doesn't. Where I had forgotten, and she reminded me that it was in their general discussion call that they had with everyone.
There was
where
an
they
information session.
an information session,
And-
so it was verbally stated,
Yeah.
right?
Yeah.
But not, there's no written FAQ that
I
they
don't
were
remember
written.
if it's in the FAQ or not off the top of my head.
You can find it, right?
But we'll have to, yeah, I mean, in the information session, the Department of Health said basically it applies to any type of healthcare personnel.
Do you have something?
Yeah, quick question, so
Yeah.
if you can direct me to that later, my name's Sean, I'm a board member, reform attorney, so I read the entire statute, and the word physician doesn't appear in the statute.
No, it doesn't appear in the statute. It
And
doesn't.
in the FAQ, they asked, the specific question was, does the definition of healthcare provider include the following, which are not listed? Physicians, physician assistants, nurse practitioners. And the answer should have been yes or no. And the answer was they spit back the definition
From the
as
statute.
written in the statute, which doesn't include physicians. They made a really good argument that it doesn't apply to physicians. I know how state regulations work, and somebody in the Department of Health may say something, but in my opinion, I don't think the law applies to physicians. So this is something I think all of us have to be super careful about,
Yeah.
because nobody wants to test it out and make money, but I don't think the state of New York has the right to all of these things for us. It's just clearly written for nursing homes, certified nursing assistants, and people like that. And the fact that the word physician doesn't apply when a bunch of other things do, so don't waste all the time.
Yeah, no, but it brings up,
Some clarification on it?
yeah, it brings up an opportunity that we have in Dalton,
Yes.
right? We were talking before this meeting, right? That we have an opportunity perhaps to spend money in a lobbying effort, right? Because like at the end of the day, the ambiguity in New York is so tight right now that, there's a substantial amount of risk on whether you do it or whether you don't, right? And it may be worth, like, our fear in Alto, the board and the legislative committees, we talk about it, is the more we ask, the more likely they're gonna tell us what we don't wanna hear, right? Like, everyone sits back around the table and like, oh, if someone asked about physicians, well, of course it includes physicians, right? That's our fear.
Yeah.
But because we have the statute on our side in New York, that perhaps we can make the lobbying effort to find the right firm to go after a soft clarification of the rulemaking in consistent with the statute, right? And that's an opportunity that I think we may want to explore. We're trying to get a lot of opinions on that because we don't want to get it wrong. We don't want to highlight the issue. We don't want to bring scrutiny to any one firm. That's why NALCO is probably the best fallback in this scenario. So certainly an opportunity.
Yeah, and Sharon, as our office partners, I mean, we appreciate this so much, this is fantastic, but as you know, we're gonna look at legislative intent, my research for this law was, no offense to my colleagues here in nursing, but New York was doing an overcorrection for the fact that the nursing industry during COVID was killing rates for nursing homes and long-term care, and it's clear that they could have said physicians and they did, so.
Just say, I love it, and also this is where I'm a litigator and Monte is a regulatory compliance lawyer, and where we have different visceral reactions to these things.
Yeah.
I'm like, Chris, go, I'm not giving legal advice. I'm fully clear, I'm not giving legal
Neither am I.
advice. I'm like, go see what happens. And like, see, it's a risk question.
Yeah.
Like, how worth it is it to take the risk?
Right.
And how onerous is it to comply? And that's the question that each of you, and you need to figure it out and yourselves.
That's right.
And I'm like always happy to defend litigation of a great staffing company that's trying to go actually getting clarification through litigation of what the law is, just by like living it and seeing if the Attorney General comes after you. But that's also not always where people go. And in fact, you just live it in this world. Maybe most of you will decide it's not worth risking business, relationships with your providers, all of those things, to sort of see what happens. So it's a both and it doesn't have, there isn't, again, it really depends on your own risk tolerance, your own profile, the opportunity you have to, consider it. Yeah.
Isn't, correct me if I'm wrong, because really this particular release, but when I read it, the reports, if I get mixed up, that if you don't comply and you don't.
If you turn to page 71 of your handbook.
And there,
Yeah, I know that's the right page, that talks about enforcement in New York.
it's
$2,000 per violation.
68.
$2 grand for violations, and then $5 grand for subsequent violations, Attorney General potential action. Oh, sorry. And a potential Attorney General action. So, conceivably, you could create a risk analysis that truly understands, I have questions in this, like what qualifies as a violation, what qualifies as a subsequent violation. So for example, I defend a gazillion labor code claims in California. Hopefully people don't know what that is. If you do, I'm sorry. But we're constantly dealing with like, what is the legal context of what qualifies as a violation, right? You have to be careful because if it's like you have one contract, is that one violation? Then you might say, from a risk approach perspective, that's one of $2,000, right? But maybe not, right? So there's so much unknown. I want to be clear, I'm not advocating for going and saying, screw it, go do it anyway. With the right client, in the right context, I might give them legal advice. But that's not necessarily where we are here. I think where there's so much we don't yet know. And that's what we're doing. And what we're really trying to do is listen to the enforcers to try to get a sense of where they're going. And so I hear you, Sean, that it's there, that the statute may not say position, but if the people who are doing the enforcing are talking about positions, we're listening. Yeah.
I promised them New York would come up. So thank you for fulfilling my promise.
We can do alternative.
Yes.
Yeah, and we don't have regulations yet in New York.
Yeah.
That is another problem, right? Like, the law is in effect. They're holding people's feet to the fire, I mean, these requiring people to register or submit massive amounts of reporting data, and we have no regulations. So that's just not frankly fair to people who are trying to comply. So the other, Red states here are Kentucky. Placements of physicians at hospitals, assisted living communities, long-term care facilities appear to us, just based on the wording of the law, to be subject to that state law. Missouri has a particularly complicated definition of healthcare facility. As we sort of parse through it and read it, we believe that from locum tenens placements of physicians, it would apply only to those placements at assisted living, intermediate care facilities, residential care facilities, and skilled nursing facilities. The state that may surprise you, I don't know, hopefully not, Florida has an old law that's been on the books since 1989. And it is, I don't know what the intent of the law originally was, but certainly as worded, it broadly applies to temporary placements of licensed, certified, or trained healthcare personnel. That's the definition of everybody it applies to, and that is very, very broad. It doesn't specifically list physicians, but I don't know how you would not say a physician is not a licensed healthcare personnel. So those are the states with laws that at least, based on the law or in New York as interpreted by the Department of Health, they apply to physicians. And then we have some of the things that are somewhat less clear with Colorado and New Jersey. Those laws apply to workers who are employees, as we understand the law. So I assume that most of you, like many of our clients, are not classifying physicians as employees when you're placing them on locum tenens assignments. They're probably independent contractors. Assuming that worker classification is correct, we do not believe that Colorado and New Jersey would apply to those placements.
You mean because that one?
Yes,
I just,
yes.
that's the
Um,
worst thing about this rate public advice.
Yeah.
Yeah.
With Oregon, the definition of personnel includes an undefined term, direct caregiver. I don't personally interpret that or think that should be interpreted to apply to physicians. And that's why I put this as a probably not. But I don't think we know enough quite yet to be confident in saying that no regulator would apply that definition to a physician. Again, I don't think that would be feasible, frankly, but I cannot promise you that a regulator would not come out differently on that. If it was interpreted incorrectly to apply to physicians, it would only apply to placements at memory care facilities, residential care facilities, and skilled nursing facilities. So again, where the placement is matters. The other state is Pennsylvania. Pennsylvania, the definition of healthcare personnel also includes a quote, direct care staff person. The definition of direct care staff person is circular and not helpful at all. It basically includes any staff person who directly assists residents with activities of daily living and instrumental activities of daily living. Okay, that's probably not a physician, right? Or provides services or is otherwise responsible for the health, safety, and well-being of the residents. What? I mean, that's so broad. That can include practically anyone. The good thing about Pennsylvania is it also is limited in scope to placements at long-term care and residential care facilities. So that sort of takes us through.
Just got one question.
Yes.
Before we leave this list, on Florida, for those of us who also see nurse staffing, that law, I think it's been around 35 years, and they have a pretty prescribed, not that I hold with it, but they do have process or kind of enforcement actions to go through it. And so I'm just wondering, is there any history over the 35 years that position and local tenants?
I don't know. I'm not aware of any, but I've not done that specific research.
Have you seen anything in New York?
Not that I'm not heard of any enforcement action.
Anybody in New York?
Say that again?
I was wondering if anybody had seen anything in New York.
Has anybody heard of any enforcement actions being taken in New York?
I don't know if they're
Right, it's been such a disaster rollout. My impression, this is just my impression, is that they are scrambling to sort of process the registration applications they've gotten and to sort of parse through all of the data that's been submitted. I'm not aware of any enforcement and don't have any clients who've had any enforcement actions or, nasty letters being sent to them from New York at this point.
For New York, this went into effect in November 2023, for anybody who hasn't registered, it's now, is there some kind of fine penalty for doing it this next 6 months later? That you're aware of?
I'm not aware of any. Yeah, I'm not aware of any being assessed. Okay, so we're gonna move on next to physician assistants. So this looks a lot like physicians. The one addition that I specifically want to call to your attention is the addition of Indiana. Indiana defines healthcare personnel who are subject to the law to explicitly include physician assistants. So this is one where I think the statute is unfortunately clear. The same comments about Colorado and New Jersey, if you are classifying physician assistants as independent contractors and that classification is correct, as you guys probably know, that's a fraught question, I know. And it's a facts and circumstances analysis, and it depends on what law you're looking to. I don't want to get into that. I just want to say those laws apply to placements of employees. So it depends on how you're classifying your physician assistants. The proposed regulations, so Maine is a probably yes up there. So Maine issued proposed regulations in, I think it was September. They are not yet final, the last time I checked, which I think was towards the end of February. They define other qualified staff to mean any other type of healthcare staff that requires certifications or licensure to provide services in Maine. And then there's a list of people who, it says including, right? So including means including these people, but not necessarily limited to these people. There is no specific inclusion or exclusion of physician assistant. There is a specific exclusion of physician. So in lawyer speak, that means we think the Maine law probably, based on the proposed regulations, assuming they go into effect as written, is going to be interpreted by the regulators to apply to physician assistants. Oregon and Pennsylvania, that is the same discussion we just had. I mean, that definition of personnel is unclear, and the references to direct care staff are unclear. We again do think it's reasonable to, as things currently stand today, interpret those to probably not apply to physician assistants. And then we get to advanced practice nurses. And here the map gets slightly even more complicated and daunting, right? So this is, again, something where it depends on the type of facility, and you've got to carefully parse through the wording of the law and the regulations. Right now, there are 10 states where either the law or the regulations or the guidance issued by regulators are clear that the law applies to at least some placements of advanced practice registered nurses. I will not go through every single one of those, because I don't know that we have time. Okay. Again, Colorado, New Jersey, same thing I've already said, right? If you are classifying these workers as employees, these laws would apply. And then the probably yes, we have 8 states. I'm going to talk about 5 of them sort of grouped together. District of Columbia, Rhode Island, New Hampshire, Oregon, and Washington. Placements of registered nurses are subject to those laws, and there is no explicit exclusion of advanced practice registered nurses. So based on just the wording of the law, we think those are probably states where regulators would take the position, yes, advanced practice nurses are subject to those laws. Maine proposed regulations, again, define other qualified staff pretty broadly. And there is, like I said, that specific exclusion for physicians, but there is no specific exclusion for advanced practice registered nurses. So that's another state where we think the law probably applies. Louisiana, nurse is there is a very convoluted analysis, frankly. It's a registered nurse as defined in a statute, and then when you go and look at that other statute, it defines a nurse as any individual licensed under that specific part to practice nursing in the state. Individuals licensed under that part that's referenced include advanced practice registered nurses. So for that reason, we again think it's likely in Louisiana that advanced practice registered nurses are subject to that law.
On that point, Monte, just so that membership is aware, we approved in the board meeting to engage a lobby firm in the state of Louisiana. We felt like it was a safe place to do a proof of concept of what it might look like for Malto to lobby something in one of these states. We chose Louisiana for a variety of reasons. The lobby firm is going to take the following 2 steps. Step number 1, is it reasonable to get clarification or elimination at the regulation level to exclude advanced practitioners, period. We think we might lose that. We think they'll say, of course it does. If they do, what's challenging about Louisiana's law, and I think a state or 2 more like this, is if you register and you have advanced practitioners in Louisiana, you have to provide proof of workers' comp to the state, right? So obviously challenging for those agencies that treat advanced practitioners as independent contractors. That would be step 2. Okay, in the event we lose, and it's supposed to be included, we want to see if we can get clarification at the regulation level to exclude the requirement to provide certificates of workers' comp for those that come into the state on a contingent basis as independent contractors, period. It's a proof of concept. We're going to see if we can do that. If we get a win from there, it might prove out that doing these little things is effective use of dollars to benefit everyone.
Yeah, so I just want to mention Minnesota. Minnesota is one where there's a specific reference to a specific subsection to define registered nurse. And advanced practitioner registered nurses are separately defined in a different subsection. So for that reason, it's a maybe, but we think it's probably reasonable in Minnesota to take the position that an advanced practice registered nurse is not subject to that law. And then, I didn't put this on the map, but Iowa, Maryland, Tennessee, those states all have healthcare staffing laws, but based on our reading of the law, there are specific exclusions for advanced practice registered nurses. So those are not a concern.
Any questions on the maps? Are they cool? How about?
Now we know what to do.
Yeah, give me a map.
Okay, so we really could have called this one requirements, not consequences. We want to talk a little bit about sort of what does this stuff affect? And this, again, it's your guide, right? There are licensure requirements, reporting requirements, registration requirements, et cetera. We wanted to just touch on 2 categories that are of big interest. Here's the map on conversion fees. I'll just let you stare at that for a second, okay? The blue states are where, everyone get out your camera, this is amazing. This must be what it's like to be like a rock star. Okay. And it's the conversion fee map. I think this will be made available to you, okay? So you can make a poster of it and put it in your offices. I just want to say, and again, I'm not giving legal advice, but, you know, contractually, you know, I think a lot of our clients are looking for, like, how do I do a one-size-fits-all contract? And I think this is an example of a, you know, unless otherwise prohibited by law, provision in your contract might be helpful to you. But the bigger issue is sitting with the fact of the prohibition on conversion fees. And one of the things we want to point out is that even if the statute itself doesn't talk about conversion fees, there may be other places in the statute that have language that effectively means the same thing. We talk about that in the guide. And also, some states have other laws that have nothing to do with this that may affect your ability on the conversion fee. So that's just a piece to keep in mind, yes.
If a client is okay agreeing to pay it in that particular state, is that okay? Like, the two parties are like, I know the law says they're prohibited, but I like the work you do, I'm a good client, I want you to work hard for me, I'll still pay it.
So that is a question of state statutory interpretation and contract. And how that state operates when the parties try to contract around the statutory obligation. In most places, it wouldn't be
Gotcha.
my experience.
All right, we get it.
Yeah.
How do you differentiate between work versus just not solicitation?
Well, it's a really good question. They're treated differently. You want to jump in? Sure. Okay, hold on, I'm going to ask my section. Okay, good.
So a conversion fee, as we sort of refer to it and as we conceptualize it, is some sort of payment of a fee if a client takes your assigned temporary worker and makes them a permanent employee, right? They owe you some sort of dollar payment. A non-solicitation clause means, depending on whether it's bilateral or unilateral, somebody cannot solicit somebody else's employee to come be an employee, right? I mean, you're right that a conversion fee and a non-solicitation sort of go hand in hand. But we see a lot more conversion fees than we do non-solicitation. And people are happy to receive a conversion fee. Often, if somebody wants to pay them a conversion fee and take their worker as a full-time employee.
Do you use that as like
Yeah, that doesn't really usually work as a workaround. It's not really a legal workaround. I mean, most of these laws, they don't necessarily use the term conversion fee. You can't have a liquidated damages fee, you can't have any sort of employment fee. They use different terms, but fundamentally, the point is you cannot make somebody pay you a fee in exchange for converting your worker to be a full-time employee.
Said otherwise, there are times when there's sort of magic words you can use in a contract that can help you, and then there's other times when it's really about the substance of what's happening. And on this, I would suggest in general, and again, I'm speaking very generally, not about anyone in particular, about who you're placing, who you're working with, where you're doing it, but this is one where the interpretation very likely would be substantive based on what's actually happening.
One more quick question.
Yeah.
Let's say you already have a contract with a client in the state of New York. They haven't brought anything up, you haven't said anything, right? But it's in that, is that contract still valid, or is it void just because you have a provision in there that has this? Do you have to go get do you have to proactively go to the clients and say, hey, time for a new contract, guys?
So I don't know that it's void, but I do think that could potentially get you in trouble with the Department of Health if they ever are able to sift through all of the information that's being
Yeah, it's
submitted.
required to send it to them, so as soon as they see it.
Yeah.
I mean, again, this is a contract question that you should want to with your employers on, but, you know, a good severance provision in your agreement, you could try to lean on if that's there, you know. But yeah, I think you should make an effort to try to fix it at the next appropriate.
'Cause there's a lot of that out there, that's why I'm asking on behalf, I know people are thinking that, right, I've got these contracts, that's not, it's in there, what do I do, right? So something to think about.
I think in New York, they've set up,
Into that, well, 28 to 22. So if you have a consultant.
Agreed.
If you have a contract prior to that date, that contract is not
I mean, based on that interpretation.
Fair, good answer.
Said otherwise, the law doesn't, in that respect.
I was gonna say there was an agreement with all that. So they all at the same time, the different states have.
Oh, maybe different, yeah, you'd have to look at it, effective date of each one.
I don't think the 2022 was New York specifically. I thought that was a different state. Yeah. So, right.
Question.
require that they work a certain amount of loads hours before they can convert? Is that one around?
It doesn't look like it, so.
A lot of states, in addition to the conversion fees, have separate language on restricted lane in general. So it's looking wherever it's in your guys'
Conversion chief applies to, like, would calling it a permanent staffing recruitment.
Yeah.
I think that's what Sarah said, right? There's the substance, right, of what's going on, right, as it can survive in this arena, right?
Yeah. A lot of times the statute says something like liquidated damages, employment fees, or other similar fees, right? I mean, they're drafted to try to encompass people not getting around the substantive prohibition.
So I've sat on the board a while for this meeting. I mean, I've got everything filled out together, but the reporting, send your contracts, send your,
Quarterly hours, bill rate, pay rates.
and all that nonsense. So I mean, whatever. But in December, we collected the city permit fees and legal. And the client and I in trouble. I mean, the people happen. And I'm, my intent, frankly, I mean, I don't know what the heck to do with this, because you could successfully help somebody out in New York, and they'll use them for 2 days, and I'm like, and you're gone. And I mean, there's almost no, at that point, better walk away from it. If you're in a business and you start seeing it too much, right? But, when the things that have already happened, I don't know whether to really send them all that stuff, or, do you go under the radar? I mean, there's a lot of judgment calls that just don't know, making in trouble already.
So I'm gonna decline on all of our behalfs to give you legal advice, without even knowing your last name or
Sure.
presenting you in front of a room full of people. Anyway, I think that's, for everybody, look, like clearly New York is a really complicated landscape, and there are so many judgment calls for our clients, for all of you in general, about when do you submit, what do you submit, how much do you, I mean, these are nuanced questions. And I think you're right to really scrutinize each of those layers. And certainly it makes sense for you to have legal advice from from somebody who understands the rules who can help you through. And I mean, part of it, maybe we can flip to the next, just to be on, some of the other, this is, the risks of non-compliance. And back to what I was talking about earlier about how you approach this stuff from a risk perspective, if there's any risk that you yourself as a business owner could end up with a criminal penalty, that's different than if you owe a $3,000 fine. Okay? So the rate, and a private right of action means somebody can sue you. So an individual person can sue you. And so, again, the point here, and there's teeth to some of this. Some of the teeth are scarier than others. But to your point, with each of these, we certainly recommend really understanding the potential consequences and weighing that in your evaluation of how to proceed. Some of these are like, that's annoying, and I just have to go through the process and do it. In other places, it's a much more strategic decision to figure out if and how you're going to try to comply with the law.
Is that affecting permanent placement at all? Or agency whether this work placement or anything not really working in those states?
Strictly from placement generally would not be subject to these laws, because you're going right in it, permanent hire from day one. Temp to perm, that's if we did wrong with that. Okay.
Any look to the next? We just have a couple minutes. I want to do this really quick, and then we can maybe try to have a few more questions if you want. Okay. I like this graphic because so often the compliance ladder feels so hard to reach. And what we want to try to encourage, and the guide is a big step, is that each of you in your companies really think about, together, and just to say compliance is a team sport. I can't tell you, I mean, I represent, 65 staffing companies. One person should not be responsible for complying. It's like, unless you're the only person who works at your staffing company. Like, it's too complicated, onerous, multi-layered, affects your revenues, affects your, potential legal risk, affects all the things. And especially as we're seeing here, it's hard. It's very hard. It's unlike paying people, for example, where if you wanted to just comply, you basically pick California, comply with California, and then you're fine everywhere else. This is not that. So it's a team sport, and you should know who at your organizations is invested and involved in making decisions, and approach this rung by rung. Who are you placing? With whom are you contracting? For what services? In what places? Is the agreement that you're using a version of an agreement that is current? Does it contemplate this stuff? Please, I know, and again, that I've represented so many staffing companies in different contexts, and like these days, I'm litigating a lot of collections actions for staffing companies where clients aren't paying, and that's a super bummer. But I'm reading these agreements, and I'm like, clearly, you guys are just so excited to get the deal done that no one took 15 minutes to sit down and read this thing. Please. And that's one thing, that's just about being owed money. This, please, because it matters. It really, really, really matters. And, we can help you. There are so many firms out there that do this. Many of you have great in-house counsel. And I say this as a litigator, I love it when you guys get in trouble because I get to help fix it. But on the front end, please take the time and develop your own models about how you approach it as an organization. Because maybe there's a New York team that's different than a Colorado team or whatever it is, or maybe there's the people who the physician team versus the whatever, whatever it is, I strongly recommend you develop a flexible model because, and I know we want to talk about how to make it all go away, but it's here. And it's affecting how we do business. So.
Well, I know it's 2:45, but I know that there's a hand or two left. Matt, you got a question?
I was actually just gonna make a comment, so.
Comment.
But first of all, thank you guys for coming, and again, I agree with you. People want to be like your statement about this being a huge value add to members. It's important for all the members in here that participate and donate to the legislative efforts. This is where that money and time goes. So I know you guys will see value in this. At the end of the day, it's not too much different when 85 came on California. Unfortunately, that legislation can spread like a virus. So we had we all had to make decisions once 85 came up for MPs and PAs. This is no different. You mentioned Chick-fil-A a couple times during this conference. At Chick-fil-A, there was a law in New York that if you went in and ate half a nugget and they asked you for $8, you go, no, I don't need a conversion fee for that lunch. I'm just gonna take it. How long will Chick-fil-A be in business there? Probably not very long. It'll be very interesting to see if you fast forward this a year or 2 or 3, and to your point, New York stuff's coming out on people that a worker works there for a day and then they take them perm. That agency's never gonna work there again. And this is a classic example of ready, fire, aims by idiotic politicians. And I have a feeling that we will be victorious this time. So yes, keep funding the legislature.
Tell us what you really think. In closing, I do think, I'm hearing and I'm sharing, right? New York is an opportunity for us, potentially, and I think we could approach it strategically, systematically, to see if we can get some clarification, and just see where it goes, right? That's the challenge with lobbying. I mentioned this in the business meeting. Sometimes you spend money and you don't know how you're gonna get to the finish line, and the opportunity either presents itself and you get a win, or it doesn't, and you feel like, well, shoot, we had to do something. Hopefully you don't leave that thinking, well, we wasted money. Hopefully you leave it thinking, well, at least we tried something because we had to, you know what I mean? So, thank you,
Thank you.
appreciate it.